on this because you see the point that in fact it follows on the position that the former Chief Justice took about the gravamen of the issue, how grave this is, and the fact that it is not enough to warrant the decision to remove a Chief Justice. Yes, there's a clear establishment of what Mr. Bento describes as a mistake. Who bears the burden of that? And if we were to use any other means to settle this, would it have served a good example for the judiciary in this instance? Is it a fair treatment as has been dealt the now former Chief Justice? Counsel.
Oh, absolutely. It's a fair treatment, all right? Look, let's start this way. Even before we go, 2 quick comments. I've seen a story on City News that says that Otchere says he will not contest. So I believe that with City News being quite a credible station, it means that Otchere will not contest the next election. So that's good, all right? Then number 2, so to start this one, Mr. Okansi, as we speak, and you know, earlier on in the week, I did an interview on this matter. It's on YouTube, okay? True. When I answered Sofa Akufu, our beloved Sofa Akufu, yes, Antua. Please, people are still going to jail for stealing chicken, plantain, cocoyam, goats, etc. Article 17 says that we are all citizens, equality before the law. Let me tell you, this matters that we've been trying to be polite, right? By not calling what the ex-Chief Justice did by its proper names. We've been trying, we've been polite, but the more you get the way Kofi is going, then the more we are tempted to actually call those infractions by their names. Abuse of office. That's corruption, please.
Abuse of office?
Abuse of office and corruption. That is what those things are.
How?
Please, look, let's stop. Let's stop this. It's not good because, look, I thought that is very clear. Because of what Justice Torkornoo is done, she served the country. You see, we always have to read the mood of the nation. What did you show? 337,000 for per diems and what? For per diems. Look at the audit report. What did he say? The daughter got $10,000. 10,000, Kofi. Who appointed Torkornoo's daughter to take $10,000? You know how much? Even today, $10,000 is $105,000. I can tell you, check Ghana Statistical Service. Millions of our citizens, not even thousands, so millions of our citizens don't earn $10,000 in 12 months. $10,000. So if you bring it to Ghana, it's $105,000. Please, can we divide 105,000 by 12 months? You see.
You asked me who appointed her.
Who paid that money to her?
The accountant. Who accessed
with what authorization did that accountant pay that money?
Of course, with the Chief Justice authorization. What are you talking about? Please stop playing ostrich. You think the accountant can tell Chief Justice that I'm not paying you? Exactly.
So if you're an accountant, if you're an accountant and the Chief Justice comes, you ask me a question. That's why I came.
Yes,
so you make your presentation.
Okay, the more you do this, then the more it's unfortunate. It's unfortunate.
No,
105,000 Ghana cedis divided by 12. Then you see the gravity of millions of our citizens don't get that. They get up and go to work 21 to 22 working days a month. The people sweeping, the Zoom Lion sweepers, all right, the security men, so many farmers, lots of people don't get $10,000 a year. That's just one triple. Then the husband also got $6,000. Look at the ticket. We spent about $100,000 on the Edem Amiga, this Torkornoo, the lady, the daughter, spent on the husband. Please, let's not trivialize these matters. And that's how come when Justice Sofa Akufu said we are trivializing the office, I said, oh, my beloved Yasantua, did you really say this? Because when you say trivialities, money that a lot of our citizens don't see in a year. Okay, 105,000. That's even just one trip. 105,000. That's a one trip. I've not added the husband soon. Now I'm ready. 105,000 divided by 12. Okay. You get
8,750
a month. Check. Even Ghana Statistical Service. Check. The last time they did somebody can Google it. Even civil service, when you go in there, it's only they said over about 90% of our citizens don't earn 8,000 a month. Please, Govi, look at it.
Hey, you keep calling me.
Yes, I want to invite you. The money is gone.
Martin,
and
that's not the issue.
You said it's not significant.
The issue of whether people are making... Look, do you know the kinds of money our leaders spend on tea?
Excellent. That's the question.
The issue is not that it's 8,000 a month. The issue is...
We're going to get... I think that point you made...
So I'm not coming to that point. And that is where we are making the mistake. We all know. Look, this morning I referenced the Cecilia Dapa cash. Okay? Mustafa Hamid is gone away with 200 here and his bunch.
Please, it's an allegation.
Oh, yes, so I'm free to mention it. If it says it's false, it should bring its evidence. 280 million Ghana cedis. The Mustafa Hamid corruption case. 280 million.
The allegation investigation.
Yes. No, it's in court.
Okay, yes.
Yes, it's in court. So I believe it. I believe what the OSP is. So I'm entitled to say so.
Right.
Listen, let's make that distinction. I haven't said he's guilty. I'm saying from the facts, money is gone. As to whether it constitutes a crime or not, that's for the court. But it doesn't stop me. Yeah, Mr. Can say it's fine. It doesn't stop me from saying the money is gone. Cancel is not true. The money is gone. I can use Article 286 to say that Mustafa Hamid, why and the Amoa and the rest, why did they take that money? Is that their monthly salary? No. Is that their fuel allowance? Is that their entertainment allowance? It is not. So once that money is gone, I can comment on it. I have not said they are guilty of a crime. So, Kofi, yes, we are all bemoaning it. That, look, yes, it's good because that will make the argument stronger. We all know that, look, when ministers travel, you hear unaccountable interest, etc. So I even mentioned in Tuesday's interview that, so we want us to have a full debate, council. That so when our ministers travel, how much do they take? That thing they call unaccountable interest. How much is it? So we know that politicians are chopping our money. So if the Chief Justice also wants to chop some, use the rules. But why you don't use the rules, not that we agree, but what I mean is that once you've gone and to do something and it's against the rules will apply. Look, the thing says that, I don't know what makes it rocket science. The policy, and it was there even during Yasantue's time, because when she went to testify, she was asked that when she was there, she was shown the document. It says, when you are going on a private visit, please use the state security. Because there's a professional trained for that. State security, that's very clear. Justice Torkornoo went on 2 private trips and didn't use the state security. One of them, she went with her daughter. The daughter made $10,000, which millions of our citizens don't make the whole year. That's one trip. The next one, she went with the husband, $6,000, right? Which also millions of our citizens don't make. So this is not trivial. Not like what our beloved Yasantua.
It's wrong. We are saying it's
wrong.
Yes.
So that is it. Just look. I know people are buzzing my phone with the reference to Angela Rayner, UK Deputy Prime Minister. She resigned because she failed to pay tax of about $40,000. She resigned. Yesterday, she had to resign. She had to resign. You see, so this thing that we're trying to justify, the more we do it, then it's like, okay, we are not ready for the reset agenda. No. So to be clear, the rules are there, and even when you go, you dig further, there isn't anything like Justice Torkornoo is not aware. Look, when Sophie Kufu was asked during the proceedings that she see that when a Chief Justice is appointed, there's an appointment letter, and inside that letter, there's per diem for travels, etc. It turns out that what is in the appointment letter is at variance with the policy this very policy that they set up there.
Which is very normal.
So why would it be at variance? You go into office, viewers, let's go step back this way. Yeah, and you know we are saying that the president in our next constitution should not choose Chief Justice, Supreme Court Justice, etc. We started making
you want that power taken from the president?
Yes, it should be taken. Article 144 clause, let's just say 144 should go. The power of the president to appoint High Court judges, Court of Appeal judges, Supreme Court judges. No, let's do an independent judicial council, not the type in Article 153. Specifically, I mean over there, when you go there, you see that the president controls at least seven appointees on the Judicial Council directly. He appoints 4, appoints an Attorney General 5, the police representative 6. The police representative will listen to the president. The army representative will listen to the president because the president is the commander-in-chief. So about 7 persons on the Judicial Council are not independent. They are not independent. Even some of the judges to some extent, because the judges are also appointed by the president. So the Judicial Council is not fit for purpose. So we change the Judicial Council. Then we also take away the powers of the president to appoint judges in Article 144, right? So we do this, then we get more independent justices. So the point, and not just you, of course, we are making the point. So you see that there's an appointment letter, a chief justice is appointed, there's an appointment letter, and it mentions what are the per diems, etc. You come into office, then you set up a different policy. Now, so ipso facto, we are already in the realms of illegality. If you think the president should not be giving you terms and conditions of appointment, say so, fight it, I'm not taking this letter. But you don't take the letter of appointment, then go into office and go and do something different. Because the letter of appointment is a contract. Once you accepted it, it's binding until it's been set aside. So if you go and do something else in office, it's an illegality. So in cross-examination, Yasantua was asked, do you see that the per diem stated in the letter of appointment is different from the per diem in this very policy? She says, yes. Yasantua was asked in cross-examination, when you're going on that one, page 22, when a chief justice is going on a private visit, private trip, the chief justice must go with a security. She said yes, she agreed. So the question is that once Justice Torkornoo went with her family relations on private visits, isn't it a breach? It's clear beyond doubt. This is what in law we call no further inquiry. No further inquiry. The thing is as plain as white. This is open and shut. Open and shut. And yet today we are being told that there's not enough evidence has been adduced, it's not clear, etc. No. And let's shift. You see, these matters we are talking about, they didn't start today. When it comes to what constitutes stated misbehavior, look, as far back as 2006, in the Agyapong case, listen what the Supreme Court said. When it comes to the transfer of the judges, it says, this is that a ban, and Justice Akufo Addo, yes, and to concurred, what I'm about to read, so for Akufo concurred, Wood CJ concurred.
She said, even though she concurred, then she has over time been reflecting on that particular Frank Agyapong case, and she's seen the flaws in the position that she took, and reason why she thinks that there has to be some reforms in Article 146 specific to the process of the removal of the Chief Justice.
And because Marty, you keep mentioning me, nobody is justifying what has happened. I have a mountain of problems with the kind of profligacy in Article 71 appointees. The kind of money they spend there for all kinds of things. Excellent. So I'm not justifying it. Yes. What I'm saying is, ever side you are on, we need to be very sober about this. And you see what Okansi just said. I think we need an Article 296 application to 146. There must be even further clarification. You know, in other places they call it high crimes and misdemeanors. It is intentionally left vague. High crimes are like murder. A misdemeanor could be a traffic offense. But when you come to some of these, my point is, if we don't, over time, tighten it up, then it will become a crude tool that anybody will use against their enemy. And I think we are getting there.
Oh, that one we all agree.
We are not justifying this.
Yes, we all agree.
I'm saying we need to be very sober.
That is why we are saying that.
We've seen Charlotte, we've not seen this one, we will see others.
Yes, and that's why we are saying that in the new constitution, Article 144, the president's powers under Article 144 must go so that there will be a more independent judiciary. His powers under Article 153 must also go so that we get a more independent judicial council. We started making this. I joined
you. See what I wrote about that?
Yes, I agree. He said, so let's read a bit to show what the Supreme Court says is stated misbehavior. At page 775, this is what that bar says. I think that The plaintiff's argument on this issue is founded on the fallacy that a Chief Justice's conduct in the administration of the judiciary can never ever be construed as a stated misbehavior or incompetence within the meaning of Article 1461 of the Constitution. Other justices of the Superior Court also have administrative responsibilities, such as the supervising High Court judge or judges representing the judiciary on the General Legal Council. I believe that it would be dangerous and not in the public interest to uphold a proposition in relation to all said judges that their administrative acts cannot ever be the substance of a charge of stated misbehavior within the meaning of Article 146. As far as the Chief Justice is concerned, I think it is reasonable to link his conduct of administrative responsibilities with his position as a judge. Then let's go on. 776, it says, justices of the Superior Courts, justices of the Superior Court are required to adhere by certain judicial ethics, which can be infringed by the conduct of a Chief Justice in the performance of his administrative acts. It is therefore unacceptable to exclude a priori all administrative acts of the Chief Justice from scrutiny, okay, as possible evidence of stated misbehavior in his capacity as a justice of the Superior Court. And you go on and on. So they went on and on and on to mention issues of bribe, etc. That if, for instance, it were established that a Chief Justice was taking bribes in exchange for transfer decisions regarding justices of the lower court, would this not be stated misconduct as part of the justice of the Superior Court? And you go on several other this is what you call it, pages. So the Supreme Court has been very clear that once the conduct, okay, goes against our laws, it qualifies. I also agree that going forward, maybe we can categorize the conduct minor, major. We can do that going forward. But right now, the law is the law. The law is the law. We have not categorized them. The Supreme Court says
with different thresholds.
Exactly. We can do that going forward. I've written that on Facebook that we should do. If you take like CI 76, the police service regulations, you see they've outlined what is a major offense and what is a minor one. So we can do. But right now, the law is the law. And you see, Justice Torkornoo knew about it. At her vetting, she said, oh, we should take away the powers of the president to be involved in this whole process. But when Justice Torkornoo took office, I didn't see her invite us to any symposium to come and debate this matter. I didn't see her table any constitutional amendment. So, I mean, what can we do? So right now, we have to apply the law as it is. We cannot change the, what do you call it, the standard. And you see, but we sometimes, let's mention these things. Let's not forget, I'm not being for only this. We also know other documents that have been thrown out in public. The contract to her daughter, the Chief Justice's own office. Her daughter was the one doing decor. How? How can the Chief Justice's daughter do decor?
The treatment of that. So again, you see, we have a wider problem. My issue is that when you leave some of these things...
A quick intervention, consider let's move on. Yes, no. It has to be quick.
Yeah, so I'm saying you are just importing other things in.
Oh, it's in public, it's been published.
Yeah,
the contract to her daughter.
I agree. The treatment of that is the issue.
No, I'm saying that.
Okay, and it's not an isolated matter. So we need a holistic dealing with this matter. My worry is that you leave all of these things in a certain discretion way. Now, the framers of the Constitution did not intend that Article 146 will be used this way.
Oh, no. These are very serious.
No.
These are serious.
You are not getting me. You are
corruption and abuse of office.
You are not understanding me.
This is corruption and abuse of office.
You need to understand.
Gentlemen, hold on.
Okay. Using public office for private gain, that's corruption.
Okay, so I want Kpebu, you conclude the point, because the point you're about starting the mentor is a substantive one. You are now getting into the intent and the mindset of the framers of the Constitution.
We're not sharing their intentions.
It's another point that we're going to get into as to whether really that was the intention of the framers of the Constitution, specific to Article 146. You say that the application now is not what was the intention of the framers specific to Article 146.
I believe.
Why is that? Quickly.
Given that the office of the Chief Justice is such a high office, and they are the supervisors of the realm, 146 is there to make sure that a person who definitely by their conduct or whatever does not merit that office will not remain there. But in leaving it the way it's been left, again, you have a situation where so much, the width of the discretion is like that it can be misapplied for a premeditated intention to remove somebody. And then we'll find all the things to put in, including things that auditors also should do. So my view is, I agree with Martin on that we need to tighten this a bit more. And all that I'm saying is that, look, what has been done is done. And it is, Justice Torkornoo said the law is the law. The law as it is now has been followed. But the question is, are we in a race to the bottom? The answer is yes. If we don't fix it, we are not going to do better in future. And anybody will come with any reasons, misdemeanors and whatever it is, and remove a Chief Justice.
But if you clearly stated in 1461, it gives the three reasons and the grounds on which a Chief Justice can and should be removed. That was the intent.
No, the intent is that you should not have a Chief Justice misconducting themselves at the same
in those three instances.
Yeah, but that's why we have Article 296. There should be further treatment. A premeditated intention. That's where the problems are.
So
and if we don't deal with that tomorrow, we'll have a problem.
Your view is that this, and I'll have you conclude on the point. The penal consequence, in your view, should have been possibly a refund and not as one of the bases for her removal.
Absolutely. If this is the issue.
Okay.
It's an audit issue.
Yes, Mr. Counsel, let me repeat this argument. We've said that there are three professions in this world. There are only three. Law, prostitution, and what? Divinity, the pastors, right? And amongst that, law is primus inter pares. So we are held to the highest standard. We are held to the highest standard. So yes, I get you. An ordinary civil servant may be asked to refund, etc. But for the citizens, when that concerns a judge, the judge applies the law, putting us on the straight and narrow. So the least thing you find that the judge has left straight and narrow and is on the this wayward path, the citizens lose confidence in the justice
all
system.
Judges or this one alone?
Oh, so this is the example that's come out.
So is that rule for all judges?
Which one? This one?
No, what you're saying that a judge has refused to hear me in court because I was not wearing a white shirt. All right? And denied my client, the necessary representation.
Yeah, but those are the rules.
Is that rule correct?
Yes, it's a rule. It's a rule that don't go to, they say, oh, the legal, they say, one way law school, they gave us, they say, they prescribe, I can't go to court with this.
No, wait.
You don't use blue shirt. You can't use a blue tunic. They say white.
Wait.
That's a prescribed uniform.
Wait. Do you know? Sorry, we are going there. No, hold on, just 1 minute. It is established that you should not visit the sins of a lawyer on their client, right? Right. And when in almost every high court, there is that laxity. That's the point I'm making. And that was my first time in that court. And I was very well dressed. And the person says, this place you can't do this. I said, oh my Lord, next time I won't do that.
The Supreme Court, they sack people.
You are not getting my point. Listen to in the Supreme Court, that is an established rule. No, I'm coming because he said something.
Yes.
We are educating the public. He is saying law is the greatest profession. I don't agree. But if he's saying that these rules must be so stringent, and I'm saying, should it be only against the Chief Justice or all of us lawyers? Well, and to the extent that, look, so many atrocious things happen in court. All right? My boss is here. Are we going to apply this high-handed rules to ourselves, or we are going to be measured in how we deal with things? Because
I think that you've gone on about how high-handedness you think it is, and the fact that yes, this is a very high threshold applied to what you describe as a very for the lack of better expression, not too grave a mistake to warrant the removal of a Chief Justice.
Yes.
The concern that Lawyer Kpebu raises is the integrity attached to the office, right, of the Chief Justice. Can such an act be excused and described as not too grave to warrant the removal, taking into consideration that office and what is expected of the office of the Chief Justice? Can that be done?
No, say it again.
I'm saying, can this act, as she has been flagged to have been involved in, be described as not grave enough to remove?
Certainly not. Certainly not. That's a very question we are answering. That it cannot be. So far, what has happened? The other names for these things that have happened is corruption. Corruption, abuse of office. That's the other names. Misappropriation of 337,000 on foreign travels. Yes. Because the money is gone, went to the daughter, went to family relations. So using public office for what? Private gain. Please. Yes, maybe we are forced to do it. I don't like, I've made noise here, ad nauseam, that we should allow her to resign. Allow her to resign. Yes, I am influenced by that largely because I've seen the executive take more. This is chicken feed when you go to the ministries, etc. And that's why I said, at least we should have allowed her to resign. Then we can have a national dialogue on these things, and especially streamline what happens in the ministries. They travel business class, etc. The president said he had banned first class. Citizens came out and said, how many airlines even do first class? Then it looks like that debate went quiet because now does it mean that our ministers are doing economy premium or they are doing business? If they are doing business, maybe we should revisit it. So you can see that it's the inequality that is fueling all of this. There's a lot of inequality in the system because even when you Google the pay disparities I was mentioning, look, when you Google pay salary, civil servant, they say, just Google it, you see, it says average public sector salary hits 2,594. Okay, this publication is 17 February 2025. That's on Graphic Online. Hey, by the way, please, in case you haven't seen, I understand the story that the city is the worst performing currency. It's false.
Yes, it's a matter we'll deal with.
It's false. Later. Okay, but when you Google this, you see, so call it 2,600 Ghana Kofi. So you see the point I was making. So if 8,750 per month, if you divide 105,000, okay, it's gone into somebody's pocket. It's a serious matter that involves millions of people.
That's why
so nobody.
Article 71 should be deleted.
Yes.
That's a different matter.
I mean, that's why it's fueling this whole debate because you see that for decades, our citizens have been very upset that the public servants and the politicians are feeding fat on the public purse. It's creating too much disquiet. That's the thing. So that's what's been behind this, and that's how come nobody would be here to say that the 337,000 Ghana cedis is no money. And that's where Yas Antoine got it wrong. And you see that if you go into the audit report, you'll find out that, unfortunately, it's not Justice Torkornoo alone who has breached this rule. Her predecessors also did. The report.
Other Chief Justices?
Other Chief Justices did. It's shown. And some were asked to also refund. The audit report... No, not at the committee, but in the audit report. The audit report that first flagged this matter, a certain Chief Justice was also asked to refund.
So why not this time?
Sorry?
No, but this is
and that Chief Justice is left office. Right? Yes, they said that Chief Justice is left office.
That's what I'm saying.
That Chief Justice is in the report. Please, just get the Auditor General's report. You see, that Chief Justice is left office. And then it further shows that it even when that wasn't the first time, others too were involved. So you see the accountability this case is solving. It means that every Chief Justice henceforth will be careful. The next Chief Justice coming will be extremely careful, knowing that the listing that Chief Justice will be out. So that's accountability. So this case is rather strengthened us. And let's always remember, Angela Rayner, she didn't pay tax of $40,000. She resigned. She resigned straight. She didn't even wait She even referred herself, Deputy Prime Minister, she referred herself to the Ethics Committee, the Ethics Advisor. And then when the advisor came out and said, yes, you didn't intentionally evade the tax, but you've broken the rule. Out of the door. And here we are dragging it and saying which hunting, yes. Public in the executive, they are spending our money rough, right? Or got the chopper nyafu. So let's solve that one too separately. But we can't say because when you go to the executive, they're able to get unaccountable impress and they are chopping the money rough. Then even where the rule is very clear, we should just sweep that under the carpet. No.
But what, is there any confusion really and lack of clarity about who the former Chief Justice could travel with and how much per diem could be paid?
There is no confusion at all. The thing says, the policy, it says that when you are going on official trips, that one, you can go with your relation, okay? The spouse, the daughter, yes. But when it is a private trip, go with the state-appointed security. It's obvious. When it's an official trip, when you go there, they provide security. They provide security. But when you're on a private visit, they don't provide security, so use the state.
The state pays for the security. Okay, but this is what she said about that proposal you made, and I come to you and then lawyer Abraham Amaleba. On the proposal of she resigning earlier, she responded to this.
Yes.
That, look, it wasn't on the table.
It was for close.
This is what she said. Take a look.
Yeah.
While Article 146 proceedings are being conducted to remove a judge, it's not an option any judge or public official can even have. There is a decided case on the matter by the Supreme Court. The suit number is J6/02/2019. Again, no one has the authority to walk away from proceedings started by the state. Judgment can be entered against you because you fail to defend yourself. And a judge who resigns or retires would still lose all entitlements that they have worked for because they failed to defend the claims and resigned or retired while the proceedings were still going on.
That was a concern, Kpebu, that if she had taken that option that you proposed, she would have lost all her entitlements. But then again, with this that has happened, she still would face that same consequence of losing her entitlements, correct?
Yes.
With the removal.
Yeah.
She will lose all her entitlements.
Yes, she's lost. She's lost all her entitlement because of the stated misbehavior. But you see, if she had resigned, what I was saying was that not just resignation, and thank you, Senior Kweku Asare is here. We hold the same opinion. If we had allowed the resignation, what I was saying was that, you see, elderly statesmen could have come together and prevailed on President Mahama to say, look, let's accept a resignation because she's worked hard. And we all know that, yes, this money is chicken change compared to what the executive do to us. We're here when Akufo Addo was flying in the sky, bathing in the sky, Sewa, Broni, etc. Right? Ministers, look at Cecilia Dapa's money. Yes, so when you analyze it from the rot in the public sector, this is certainly chicken change. That's how come I kept saying no, let her resign. But she didn't ask for it publicly, for people to step in, right? Yeah, she didn't work hard at it. But as for the committee case, it was clear that she was going to lose because there was nothing she could do to win a case. The thing says when you're going on a private visit, go with the state security. Simple question. When she went to Tanzania, did the policeman go with her? No. This one, what further evidence?
Okay.
What further?
I need to. I'm going to. Let me just.
It's important to say it wasn't open to her.
No. It could have been done. Okay. If we had all
against the law.
Hold on.
Oh, it could have been done.
That's right. So you see,
it could have been done.
The point is clear about what Kofi Bento takes a path that he's not justifying what has happened. There's wrong that has been done. How the wrong is to be remedied, or who should carry the burden of that wrong, is one question that he raises as to, yes, even if it was the request of the former Chief Justice to have been paid a certain amount, who was to dispense that amount, even if it was captured in a particular policy, one. And secondly, the fact that this penal consequence is too grave to warrant really this particular sacking that we have seen. I want to find out from you if this sacking is a consequence that matches the offense that has been established of stated misbehavior in this instance.
Thank you. I think the law is the law. And when it comes to sanctions, the law does not thrive on an assumption that it should be commensurate with the offense. Sometimes, thresholds are set, sometimes not. So it depends on the status and gravity, of the offense. In this case, I would say that for somebody who has worked for about 21 years, giving dedicated service to the nation, it will seem at first sight, to be too punitive, to lose everything. A way could have been found. We could have circumvented and, say that, well, ultimately she must be removed. But looking at the surrounding circumstances and the 337,000 and all that, and the fact that the president is the father of the nation, something, could have been done, and say that, well, rather than go home persualess, we would retire you. You can, enjoy all your benefits, including your retiring benefit. That could have been one way out, or, well, you've done it. We'll sanction you, but at the same time, we'll allow, the constitutional provisions to be implemented in your favor. So that's my immediate reaction. Having said that, this whole Torkornoo CG removal process, I would say that the former Chief Justice, Torkornoo, was a victim of many circumstances. A victim of many circumstances. I can outline, say, 5. The first, was the president's meeting with the lawyers, the NDC lawyers, and expressing a view. Initially, my take on, the president's meeting, then the NDC's presidential candidates meeting with the NDC lawyers, was that, yes, I mean, every presidential aspirant, will say this or that, and as Martin Kpebu said, they can make, political U-turns. Nobody will worry himself or herself about that. So that's, the first. The second, the absence of any definition in the Constitution on what will amount to stated misbehavior. Because the framers of the Constitution thought it desirable to outline, certain everyday, words and to assign meanings in the Constitution in Article 295. But with regard to stated misbehavior, the framers, didn't say anything and let it ajar so that it will depend upon interpretation, and judges, are also, ordinary mortals. When you give them the chance to interpret. So you see in the Frank Ejechum, and EGN Bright Akwete case that, the retired Chief Justice, Professor Dateba, went to lengths. But still, if you read, the judgment, and, luckily, Kpebu, has walked us through pages 766 and 767. No, you see that even after outlining examples, respected, Justice Dateba still left it open, meaning that the categories are not yet closed. So day in, day out, other, things could come in which will qualify as stated misbehavior. So that's the second, the absence of any, definition to guide the court. The third, self-induced, was the nomination and subsequent appointment of Torkornoo, out of 10 by the former president, which, was severely criticized, but the former president, didn't heed, any call to take a second look at that. For me, that was a catalyst,
There were other senior persons.
Sure.
Than her.
Taken out of 10. Then the fourth circumstance of accident, the fetish that we are making of our precedents. So the Frank Agyapong stood guard over any remedial measure, favorable measure, for Torkornoo. Stood guard because the Frank Agyapong thing had interpreted Article 146 holistically in accordance with the canons of interpretation, that in interpreting or construing a provision in the statute, you do so, so as to make a consistent meaning by looking at the entire. So you don't merely look at Article 146, 6 to 11 in relation to the removal of the Chief Justice, but you also go backward to Article 146, Clause 1, which will provide guidance on stated misbehavior. This is, what has caught up, with this whole saga of total loss. If in Frank Agyapong, the Supreme Court, had said, look, we notice first and foremost that a Chief Justice can only be a Chief Justice, if he has served a certain number and being appointed from amongst, the justices of the Supreme Court. The question is, what if the Chief Justice is not coming from the bench? Would Article 146, 1 apply to such a person? Because the person, wouldn't in the first place have been a justice of the Superior Court upon elevation, to the high office of, Chief Justice. So the Supreme Court in Frank Agyapong, I think missed the point when they put the two together and said, by parity of reasoning, since, you can only be a Chief Justice, if you are a Justice of the Superior Court, and therefore whatever affects, your position or status of Chief Justice, must relate back to your status as a Justice of the Supreme Court. This is where the harm is. It's a misconception because Article 146, Clause 9 refers to in each case. So the Supreme Court should have segregated that you may be a Justice of, the Supreme Court. If we are looking at your exercise as a CJ, yes, Article 146(1) says stated misbehavior. Stated misbehavior, of a Justice of the Supreme Court. Therefore, we would, divide into two, limit ourselves to Justices of the Supreme Court, and then limit ourselves to the CJ who is being removed. If they had, told that line, we wouldn't have a situation where, it relates back
to the instance.
When the Constitution says there shall be no retroactive legislation, but you are interpreting a provision of the Constitution retroactively. I don't think, their lordships were right, insofar as they did that. And that is, what has affected former Chief Justice Torkornoo. Then the fifth, self-induced. Why ask a daughter to be a contractor in respect of some services in your office. She brought it, upon
decorating
herself.
an office.
Yes, she brought it upon
and the
herself.
furniture and all of that.
Yes. The other one, my good friend Kofi Bento, was struggling, to align. You see, it is an audit issue, yes. But who is the head of the judiciary? The Chief Justice. Article 125, Clause 4 is clear. The Chief Justice shall be the head. So the buck stops on her desk. So whether an accountant or the auditor or whatever, any person, it is the Chief Justice. And she could not claim ignorance that being the head, the buck stops on her desk. Being the head, the buck stops on her desk. So trying to claim ignorance that, well, as my good friend will put the meeting baby, and now they are there no buy, and I mean, so sign. I mean, it will lie in the mouth, to say so. Mm-hmm. So she must have known, the consequences, of signing. But after all, who approves and who disapproves? This is the Chief Justice. Mm. But the most serious of the stated misbehavior, from my point of view, was the attempt on her part to use a certain provision of the Civil Service Act to recommend the appointment of, some 5 persons,
yes,
as justices. That constituted judicial misconduct.
So that's it's serious, more than the misappropriation of this.
Judicial misconduct. See, if you look at the Judicial Service Act 2020, Act 1057, mm-hmm, as chairperson of the Judicial Council, she has the following powers. I'm reading Section 7. That's stated misbehavior.
It is.
Stated misbehavior. So, members of the service and vacancy. Mm-hmm. Where there is a vacancy, that's Section 7, I'm quoting. Where there's a vacancy, A, under paragraph H, under paragraph B of subsection 3, or subsection 4, or subsection 2 of section 9, or B, as a result of a declaration under subsection 6, or C, by reason of the death of a member, the Chief Justice shall notify the President of the vacancy, and the President shall, in respect of a person who is appointed by the President under paragraph N of section 5, appoint a person to fill the vacancy. Uncle, she was trying to lift this particular provision, and under this, wrote a letter to the President, mm-hmm, listing 5 persons. And when I looked at it, and Article 144, I felt, it amounted to judicial dishonesty. And for that, I was on air that, she should be reprimanded. And on one of your shows, mm-hmm, I did say that it could cost her job for trying to be deceitful. For me, that could have, and Kweku Annan, read into it and quickly.
That's what's coming to, because this particular one was captured in Professor Stephen Kweku Annan's petition, which was thrown out by the former president, Nana Akufo Addo, that it didn't constitute any grounds whatsoever for any misconduct. But this same concern has found favor in the sight of another
it's very
committee.
Serious. Very serious. It meant that she was trying to procure the elevation of those 5 justices by fraud. And fraud vitiates everything. As a Chief Justice, she had, subscribed to the oath, to to act in accordance with the Constitution. Why try to use, a provision not in the Constitution as a basis for appointment of, persons to the Supreme Court? I mean, if there was any stated misbehavior, I would just rely on that and say that, that was sufficient. I will not bother. But because, Kofi says that the 337 or this thing, I want to, tell Kofi, you see, if you admit to some infraction, and so by which they say, refund it, the High Office of Chief Justice, it is not kitikiti. And the Martin, refers to our good friend, yes, Antoine. Former Chief Justice Akufo would always, usefully remind everyone, especially, law students going to take their entrance exam, that when you take the exam and the pass mark is 50, and you had 49, 0.9, now can say kitikiti in Kaminya 50, and kitikiti in law doesn't exist. You either had a 50 or you didn't have a 50. So there's nothing like a kitikiti. Therefore, 337,000 will sound kitikiti and grating to the ear of civic-minded person. But the law is the law. Whether it is kitikiti or did she do what was in consonance with the Constitution? No. So she had contravened the Constitution. She had contravened the provisions of the Judicial Service Act, and she wears two hats. The hat of the judiciary and the hat of the judicial service, and both she contravened. So for me, I mean, it was, the committee was right, but we could also deal with the issue of retiring benefits, with some human face. Is it, equitable that she should go home persualess? Does the president have the power? And the president has, gargantuan powers under Article 72 of the Constitution going to the clemency. So, I mean, the president has all that. Where I will fault the president is that he acted too swiftly when the report was submitted and he received it. As, our sages will put it, he could have, taken it home to sleep over it and obtain some advice from his pillow. I'm quite sure that, something better than what has happened could have come out of that. But not too long after, receiving the report, that is where I think, as father of the nation, he can take a second look at the decision.
But could he, because the specific dictates of the Constitution, Article 1469 specifically prescribes the action of the president after receipt of the report of the committee. He is bound to act. Could he have done any differently?
You see, that's why I said fetish. We become so fetish, that we cannot even wriggle ourselves out, of some quagmires. If you look at Article 146.11, Article 146.11, I believe that...
let's put that on the screen. 146.11 gives... the president also could have done otherwise. That 146.11 states, and I quote, the president may at any time revoke a suspension under this article.
So, before reception of the report of the committee, knowing that this has happened, we're always on there suggesting that, look, let the Council of State members, let the Judicial Council...
Specific about the suspension, yes.
This is what I'm saying. Let, the sages, let them meet, with the President and, Justice, former Justice, Chief Justice Torkornoo in chambers, and then try to, water down some of these things before the reception of the report, so they will know exactly, because he had the power to lift. Now, if he lifted it, then it means that he would have made the committee's work redundant, isn't it?
Well, yes. So, but at the point of the committee submitting the report, this particular recommendation you make has already passed.
Sure, that's what I'm saying.
Yes.
So if they had met,
if
they had met, who says that if they had met, they couldn't, have worked something out?
Right.
They could have done it, but it was not done. Then, 1469 says that in it. So when you get to 10, the president has been boxed into a corner, a point of no return, just to act, in accordance with the recommendations of the committee. So it is not a right for the president, whether he has a right or... It's not just a right, but it's also an obligation to act in accordance with the recommendation of the committee that probed the CJ. So we've given to ourselves a constitution that has become unfriendly, and then we are also bound by Article 1294 that whatever the Supreme Court says, therefore the Supreme Court previous decisions on this issue have become sacrosanct. So again, we cannot box ourselves out of it. So the way forward is for the entire nation. And now that we are reviewing, the committee, for the review committee, to suggest, a middle path. When it happens that way, what path may the president chart?
Okay.
Thanks for watching. Like and share the video. You can also drop your comment. Please don't forget to subscribe. Click on the bell to turn on the notification.